Hello, I'm Adam Kielich, principal attorney at the Kielich Law Firm in Bedford, Texas, where I help clients in the Dallas and Fort Worth area with their family law, employment law, and consumer law needs. Today's video is going to address 5 common divorce questions. These questions are extremely common, and most people have these questions when they're thinking through getting a divorce. In addition to this video addressing the questions, these questions are also addressed in more detail on my website through my blog, so if you're looking for additional information, that may be helpful to you as well. So question number 1 is, how long will the divorce take? Under the Texas Family Code, all divorces are required to wait at least 60 days from the date of filing the petition for divorce until the date that the judge can grant the divorce, unless there's an issue of family violence, in which case a divorce can happen earlier. So the briefest period of time in between filing a divorce is normally going to be 60 days. As far as how long it can take, that's really an open-ended issue. Sometimes divorces that are particularly complex, or the parties are aggressively fighting each other over every detail, sometimes those divorces do go on for years. That's definitely more of a rare situation, but it can happen. In my experience, the average divorce is usually wrapped up between 6 to 12 months, and if there's a good deal of conflict, maybe within 2 years. But the vast majority of divorces that I deal with tend to be fairly agreeable, or we're able to get the parties to an agreeable place and save spending a bunch of time and money fighting through court, and just get the parties to where they need to be and get the divorce done. But of course, every divorce is going to be different, so you may actually have a divorce that we can get knocked out in 60 days. But on the other hand, you may have one of those particularly contentious divorces, and you're going to be at it for a few years. So that's basically the answer there. Question number 2 is, how will my divorce be decided? Well, there's a few different ways a divorce could be decided in Texas. The parties could reach an agreement on their own, and then that agreement becomes the basis for the divorce decree that the judge will sign. The parties may go through a mediation process instead of just agreeing between themselves, in which a mediator will help them reach that agreement, which then becomes the divorce decree. In more rare cases, a divorce may actually go through a trial through the courts, in which case a judge or even a jury will decide some of the issues in the divorce, and that will form the basis for those decisions. In extremely rare cases, the parties will agree to present their arguments before an arbitrator, which is like a private judge who will issue a ruling, and then that ruling will form the basis for the divorce decree. By and large, the vast majority of divorces are resolved either through an agreement between the parties or an agreement through mediation. The reason for that is most marriages, quite frankly, do not have that complicated of assets or that complicated of issues between the children that it's impossible for the parties to reach an agreement without going to trial. There may be some conflicts, there may be some issues that take some work, but usually the parties will understand that it's probably not worth spending tens of thousands of dollars on both sides to take a case to trial just to figure out who's going to get the checking account or the cars. Like that just doesn't make sense. So that is what happens in most cases, but sometimes a divorce will go to trial, and ultimately the judge or jury, or the combination of the judge and the jury, will decide issues in the divorce. Question number 3, how much will a divorce cost? In your divorce, there's basically 4 sources of costs that you're going to spend money on. First is filing fees to the court. Second are service fees. Third are litigation costs. And fourth are attorney fees. The filing fees in most cases, are only going to be a few $100s. You've got to pay the court to be able to get in the door and get your case filed. Along the way, depending upon what occurs, there may be additional filing fees to file certain types of motions. But for the most part, the initial filings by the parties will be the extent of filing fees that get paid. As far as service fees, a party is entitled to be served by a process server when divorce is filed. So the petitioner will normally pay to have the respondent served. There may be additional service fees, serving subpoenas in the case, or other things, but for the most part, in most divorces, you're really going to just have that initial service of process. Service is typically between $75 to $100 per attempt or per document served. Third, we talked about litigation costs. This is kind of open-ended. It depends upon what happens in your case. These litigation costs can be small things like postage or printing costs, requesting documents from financial providers and banks. If a mediator is involved, then somebody's got to pay for the mediator, so that's going to be some additional costs. And then fourth, of course, are attorney fees, and that's going to run really based upon whatever work the attorney has to do. So the more complicated, the more involved your case is, the more likely you're going to pay more in attorney fees because the attorney has more work to do. And conversely, the easier your case is, the less attorney fees you really should be paying. As a whole, when it comes to the cost in the divorce, the amount of conflict and the amount of complicated issues are really what drives the cost. If there's really complicated financial assets or businesses that have to be valued, that's going to add a lot of cost because we've got to get professionals involved. Documents have to be created and sorted through just to figure out the valuation. And oftentimes the parties disagree. Whoever's taking the business wants to give up as little as possible in exchange, and the other party wants the exact opposite. So that can drive a lot of cost. When kids are involved, sometimes parties are not making cost-benefit decisions. They're just thinking about their relationship with their children, and there's an emotional drive there, or just a drive to be a good parent. And the fact that they're not making a cost-benefit decision is not necessarily bad. Your kids are not easily reduced to a dollar amount. So that can be a tremendous source of conflict and in turn cost in a divorce while the parties argue or disagree about how to divide time and rights over the children, how child support should be allocated, and so forth. So that conflict is really going to drive the amount of cost. And the problem, of course, is that you don't control just the way that you view the case or the amount of conflict you insert, but also how much the other party is inserting conflict, how rational they are, what their priorities are. That's all going to drive it. So you may be interested in trying to put together an agreement and do it very simply, but the other party may have different ideas. And if they're looking at more conflict, you can't really avoid it but to get in there and battle it out with them. For the most part, I would say that the cost on a divorce can vary greatly. A divorce that's very simple and the parties have an agreement right at the beginning, something, what we often call an uncontested divorce. In addition to the filing fees, you may only be paying a few $100s, maybe $1,000 to get all the documents done and get that done with the court. On the other hand, if there's considerable disagreement, the parties could be spending thousands or even tens of thousands of dollars to reach a conclusion. Oftentimes, if the disagreement is bad enough that a case is going to go to trial, it's easy to expect that you're going to burn $10,000 or $20,000 or more on litigation. just because the amount of work that goes into a trial is so enormous. But if there's some disagreement and the parties can reach some kind of resolution through mediation, often the parties are only spending a few $1,000s per side to get there. But of course, as I've said before, every case is going to be different. So don't assume that if you've got mediation, your costs are necessarily capped out at a few $1,000s. It may take a long time for the parties to get to a point where they can sit down with a mediator and actually reach a resolution. Question number 4, who gets the kids? There is no set rule. I've had divorce cases where both parents have got primary custody or have been awarded time as the custodial parent over the children. In Texas, there is no rule, there's no presumption that either the mother is the better custodial parent or the dad is a better custodial parent. In Texas, the judge makes the decision based upon what's in the best interest of the children. And that's really the only rule that the Texas Family Code lays out for those kind of decisions. Now, of course, there are a number of factors that a judge can consider in deciding what's in the best interest of the child, and so it can be a very complicated question to answer. But again, most divorces are going to end in some sort of agreement between the parties, so whoever gets the kids will usually be decided by whatever the parties agree to in order to get the divorce done. So that may be one parent having the majority of the time over the other one. It could be some sort of custom or creative kind of possession schedule where the parties are dividing time equally, or something similar to an equal share of time. So when an agreement is involved, the answer to that question is whatever the parties want. When a judge decides, it's going to be what's in the best interest of the child. Now, a lot of people think that courts normally decide that the mom is the person who should be the custodial parent over the kids, and there's some sort of unwritten rule within courts or between judges that this is the case. There is no presumption. There's no unwritten rule that this is the case. And like I said, I've had dads be awarded the custodial parent as well as a mom, even by the same judges. So I don't know that I would agree that the mom walks into court with a stacked deck on that issue. The exception I would say to that, though, is that when the judge looks at the parenting situation between the two parents to decide how to allocate time between the parents over the children, the judge does start off in Texas with the idea that what's called the standard possession order is what's going to be applicable. And the Texas Family Code does say that the presumption is that the standard possession order is in the best interest of the children. And that standard possession order is the usual one parent has the kids the most of the time. The other parent has the children on every other weekend and Thursday evening. Because of the way that that's divided, the judge is naturally going to look at whichever parent is going to have the most amount of time with the kids is going to be the parent who normally does the day-to-day parenting over the kids, because they're going to be typically on their own doing that day-to-day parenting. And so the court's going to look at often who does that day-to-day parenting. And often the mom does win in this regard, not because the judge has a bias, but because as a whole, moms tend to be the parent who does the day-to-day parenting. They're the ones who take the kids to soccer practice and dentist appointments, take them to school, pick them up, make dinner, all that kind of sort of normal parenting functions. And especially here in Texas, we see a lot of stereotypical division of parenting and family duties between the parents, where mom is the caretaker, dad is the breadwinner. Well, if that's the normal situation when the parents live together with the kids, when you split the parents apart, you still have the mom in that caretaker role, the dad still in the breadwinner role. And so what the judge does is give the kids to the mom, who's the caretaker, and let dad be the breadwinner, and then pay the child support. And that's not a bias. It's just that's the way that a lot of families are set up. And you may have a family that's the opposite way, in which case dad's probably, as the caretaker, going to get the kids, and mom's going to pay the child support. A judge should not be locked into the assumption that stereotypical division exists. The parents could equally divide time and responsibility with the kids. Both parents work, both parents trade off doing that kind of day-to-day parenting. That's going to make that division much more difficult, and maybe the judge has to opt for something that's not the standard possession order. So the individual facts of the situation should and often do override any sort of stereotypical or division or assumption that the judge might have in mind. And number 5, who will pay child support, or will child support be paid? And we kind of talked about this with the last question. But generally, if one parent is awarded custodial parenting through that standard possession order, the other parent is going to pay child support. If there's some sort of creative or alternative possession schedule other than the standard possession order, child support might be paid depending upon how that schedule breaks up time and what the parents, usually the parents have agreed to some sort of alternate schedule and how they've decided to allocate the financial obligation of support between the parents. So for example, if you've got that standard possession order, and maybe mom is the custodial parent and dad's paying child support, dad's going to pay child support based upon the guidelines laid out in the Texas Family Code, unless there's some reason to go above or below those guidelines. When you have some sort of alternative possession schedule, like a 50-50 schedule, what often happens in that situation is both parents are providing home space for the kids, they're paying for meals, they're paying for clothes, all that kind of stuff. So they're both really paying equally or close to equally the financial obligations to support the kids and making sure that the kids have what they need. So in that situation, there may not be child support paid at all by either parent, but there could be that sort of 50-50 situation, but one of the parents still pays child support to the other one to make sure that the kids have what they need at both houses. Whenever those alternate schedules are involved, that's almost always occurring because the parties reach some sort of agreement, and it's going to be up to the parents to decide how that's going to work and how they're going to split up that financial obligation. But almost always, if the standard possession order is awarded, child support is going to be paid by the non-custodial parent based on those guidelines, unless the standard possession order was part of some agreement by the parties and child support is not owed. I've done several divorces where either there was no child support paid or reduced child support was paid based upon some agreement between the parties. Some judges in Texas are fine with this, especially if an attorney is involved, because they feel like the parties have reached some sort of agreement that's supposed to work for the kids. And if an attorney is involved, at least there's been advice and serious consideration rather than one parent trying to beat down the other parent over the child support issue until that parent gives up and then no child support is owed. Judges don't want to see that situation occur. So sometimes, even when the parties have an agreement, but there aren't attorneys involved, the judges will reject that and tell you to come back with a proposed divorce decree that has child support in it. But I've never personally had that happen to myself. Although I am told that in other parts of Texas, there are judges who just absolutely will not sign a divorce decree if that child support isn't being paid by one of the parents. So like everything else, your individual situation and whatever agreements might be in place or become in place at some point down the road, those individual circumstances will drive whether child support is paid and who pays child support. So that's really it. Those are the 5 basic questions. This video has probably got on long enough that we should cut it off here. Again, as I said at the top of the video, if you're looking for more information about these questions or other issues with divorces, I've got lots of content on the blog on my website, and a link will be in the text below the video. So I'd encourage you to go check that out. As always, I want to thank you for spending your time listening to the video, and I hope it was helpful, and I'll see you next time.